Start. Learned Senior Counsel for the applicant and Mr. G. S. Godbole for the respondent numbers 1 to 4. By this civil revision application, the applicants are challenging the judgment and order passed by the Appellate Bench of Small Causes Court dated 9th July 2012. The case of the applicant is that the applicant were subtenant in respect of the suit premises, which is defined in paragraph 2 in bracket 1 of the civil revision application. The original tenant was the Bank of India. The respondent numbers 1 to 4 had filed a suit only against the Bank of India, being suit number 1963/6065 of 1986 on grounds of bona fide requirements. The applicants state that they became direct tenant of the landlord by virtue of Section 15A of the Old Bombay Rent Act, and despite which they were not made party to the said suit, much less they were not informed about the pendency of the suit. The applicants remain in possession of the suit premises, and accordingly the respondent issued obstructionist notice being number 73 of 2003. The applicants had challenged the said obstructionist notice in TE and suit number 195/208 of 2001. The learned single judge of the Small Causes Court, Mumbai, by its order dated 9th July 2012, allowed the obstructionist notice and directed the obstructionist to vacate the hand over the possession of the suit premises. The single judge held that obstructionist number 3 failed to prove that he is a protected or deemed tenant even after exemption of the suit premises under the Maharashtra Rent Control Act. The obstructionist number 3, though inducted as subtenant of defendant number 3 by consent of the plaintiffs, was held to be still bound by the decree under execution. Accordingly, the learned single judge held that the obstructionist numbers 1 and 2, claiming to be licensees, were no longer protected in view of exemption of the suit premises under Section 3 in bracket 1b of the Maharashtra Rent Control Act 1999, and the decree of eviction was binding on them. The applicants herein preferred an appeal before the Appellate Bench of the Small Causes Court, Mumbai, being miscellaneous appeal number 137 of 2012. The Appellate Bench, by the impugned judgment and order dated 3rd May 2018, dismissed the appeal by upholding the findings of the trial court, which required no interference. Being aggrieved by the impugned judgment and orders, the applicants have preferred the present civil revision application. Mr. Thorat, learned senior counsel for the applicants, has submitted that the court below has failed to consider that the applicants were the subtenant and fell within the definition of tenant, which includes subtenant as permitted under contract or by consent of the landlord under Section 7 in bracket 15 of the Maharashtra Rent Control Act. He has submitted that the applicants were inducted into the suit premises as subtenant by the original tenant, Bank of India, with the consent of the landlord. Mr. Thorat has submitted that Section 25 of the Maharashtra Rent Control Act provides that the subtenant shall become tenant or determination of tenancy. It is provided therein that when the interest of the tenant of any premises is determined for any reason, the subtenant to whom the premises has been lawfully sublet and such subtenancy is subsisting from the date of commencement from the Maharashtra Rent Control Act, and that subtenancy is permitted by contract between the landlord and tenant, which is the present case. The subtenant shall, subject to the provision of this act, is deemed to be tenant of his landlord on such terms and conditions as it would have held if the tenancy has continued. Mr. Thorat has submitted that court below has considered section 3 in bracket 1b of the Maharashtra Rent Control Act to be applicable, and which provides that the premises let to inter alia banks is exempt from the Maharashtra Rent Control Act. He has submitted that the original tenant, being Bank of India, was accordingly exempt from the applicability of the Maharashtra Rent Control Act and could be proceeded by the respondent landlord under section 106 of the Transfer of Property Act by issuing notice of termination as has been done in the present case. He also submitted that in the suit which was filed by the respondent landlord, that is suit number 195/208 of 2001, the applicants were not joined as party defendants. He has submitted that the applicants were protected under the Maharashtra Rent Control Act, and the exemption under section 3 in bracket 1b was not applicable to the applicants, though applicable to the original tenant, Bank of India. The applicants were deemed tenant under section 25 of the Maharashtra Rent Control Act, and he has submitted that the respondent, by not adopting appropriate remedy under law, which would in this case be the Maharashtra Rent Control Act, have merely issued obstructionist notice for evicting the applicants. He has accordingly submitted that the court below has not construed section 25 of the Maharashtra Rent Control Act, by which the applicants were protected under the Maharashtra Rent Control Act. Stop.